The televised trials of O.J. Simpson and Ted Bundy are just two examples of criminal cases that became must-see TV and pop culture events in the United States. But is it unconstitutional to have public broadcasts of criminal trials? The Supreme Court answered this question in Chandler v. Florida. In 1977, the Florida Supreme Court initiated a pilot program through a judicial canon that allowed criminal trials to be broadcast to the public without the consent of the trial participants. Previously, Florida, along with many other states, didn't allow public broadcasts of criminal trials. Under the pilot program, broadcasts of any court proceedings were subject to broad control by the trial court. Further, the accused could file a pretrial motion to object to media coverage and explain, on the record, why he or she didn't want media coverage of the case. In the same year, Noel, Chandler, and Robert Granger, two Miami Beach police officers, were charged with conspiracy to commit burglary at a Miami Beach restaurant. The trial was broadcast to the public, and Chandler and Granger were found guilty. Chandler and Granger moved for a new trial, claiming that because the trial was broadcast to the public, they were denied a fair and impartial trial. The trial court denied the motion, and Chandler and Granger appealed. The Court of Appeals affirmed the trial court's holding. Chandler and Granger appealed to the Florida Supreme Court, but the court denied review. Chandler and Granger petitioned the United States Supreme Court for review.